any of these gatherings. Good morning, everybody, and many thanks to ABA and to USIP for organizing this panel and for having me participate as moderator. We have a very distinguished group here this morning to discuss international legal frameworks and capacity building related to cybercrime. Before I begin, I wanted to introduce myself and give a very brief context, and then we'll turn to our panelists. I work in the State Department's Bureau of International Narcotics and Law Enforcement Affairs, where I'm the acting director of the Office of Global Crime Issues. For those of you who haven't heard of INL, we help our foreign partners tackle the most pressing international crime issues, illegal drugs, law enforcement that impact the United States and its interests. We have capacity building programs in about 90 countries around the world, and our partners to implement those programs include U.S. criminal justice agencies like the U.S. Department of Justice, international organization contractors, non-governmental organizations, the American Bar Association among them. And with our help, the idea is that countries are better able to confront, to address crime, and to work with us to address crime before it impacts our citizens. Our classic mission, international narcotics and law enforcement, our classic mission has been counter-narcotics, and that still is a critical area of work for us, especially in light of the opioid crisis. But we've also seen our programs evolve over the years to meet emerging threats. And of course, it goes without saying in this setting, countries around the world, developing and developed, have seen tremendous challenges facing the criminal misuse of information and communications technology. And the crimes, of course, go from ransomware to botnets to cyber-enabled fraud and online child sexual abuse. While strong national laws and capacity are important to combat this threat, of course, cybercrime is the quintessential transnational crime, and we need international cooperation to effectively combat it. International legal cooperation, such as mutual legal assistance, is necessary to pursue cases when the impact and the evidence may lie across borders. And while every country's law doesn't have to look exactly the same as every other country's, some commonality, some interoperability helps with cooperation. By the same token, bringing countries, if not to the same level of capacity, but trying to bring countries to a similar level of capacity fosters cooperation and makes it more feasible. Now, the tools that are out there, some of which we'll discuss today, range from bilateral agreements like mutual legal assistance treaties, informal networks to foster law enforcement to law enforcement cooperation, the G7 24/7 network of high-tech crime points of contact is one example. Multilateral instruments, we'll talk about the Budapest Convention, even the UN Convention on Transnational Organized Crime, or UNTOC. For the US, our cybercrime policy and our programs, because we do a lot of capacity building, we support a lot of technical assistance globally in this issue, as with other issues, is to promote accession to the Budapest Convention. At the technical level, it outlines, and we'll hear more from Rudy and others, it outlines the essential elements of a strong domestic counter-cybercrime regime. And at the policy level, it reflects the values of liberal democracies in terms of promoting free speech, a multi-stakeholder approach to cyberspace, and respect for human rights. In contrast, and this will be part of our discussion this morning, some countries have begun advancing alternative or contrasting approaches that stress a more top-down authoritarian approach that may threaten free speech, human rights, and insert greater state control, I would say, into cyberspace and the response on specific issues like cybercrime. So we'll talk about what is out there, what opportunities are presented by the existing international legal framework, what the challenges are and alternative views. We'll also talk about partnerships, including capacity building partnerships and the important role that they play. Now, I'm not going to try, and what I hope to do is we'll have relatively brief presentations from each of our panelists, and then we'll open it up for comments and questions from the whole room. And when I say comments, I envision this as participatory, and that the only expertise certainly doesn't, on this issue, certainly doesn't lie here at the front of the room. I will ask that when we have questions or comments, just that you introduce yourself, say, give your name and your affiliation. I am not going to do lengthy introductions of the panelists because each is sufficiently distinguished that we would use up the next half hour if I went into the full depth of their bios.
Take your time, please.
Sure. Rudy is not shy. In the order that we'll go, though, Rudy Orjales is both a consultant for the Council of Europe and the chairperson of the group of experts on cybercrime for the Organization of American States. He was a DOJ senior trial attorney at the Computer Crime and Intellectual Property section, where he prosecuted many major cases. He was a legal attaché at the U.S. Embassy in Argentina and an AUSA in San Francisco. Kenn Kern, all the way to my right, is the Chief Information Officer and the Special Assistant for International Relations at the New York County District Attorney's Office. He was the Deputy Chief for Cybercrime and Identity Theft there, where, again, he prosecuted a wide variety of high-level and high-impact cases in identity theft, financial, and cyber frauds. And he was a prosecutor with the ICTY, the International Criminal Tribunal for Yugoslavia, and participated in the Milosevic trial. Which brings us to Mary Greer, who also worked with the ICTY. Mary Greer is the Senior Technical Advisor in Criminal Law at ABA Rowley. Her work with the Rule of Law Initiative, then Sealy, dates back to '98 when she was a liaison in Bosnia. She designs and implements programs in global criminal justice issues like cybercrime, but also sexual and gender-based violence and financial and organized crime. So we have a wealth of perspectives. I am now going to silence myself, turn to Rudy, and then we'll go to Kenn and then to Mary. Rudy, over to you.
Thank you so much. And good morning. I was recently in New York City. An aunt of mine passed away, and I had the responsibility of going through her things to basically close out her estate. Do I need the microphone?
Yes.
Okay. And in going through her things, it was like going through a museum. One of the things that I found was this. A transistor radio, which were developed in 1955. It revolutionized electronic communications like nothing ever before. It sold over 1 billion. It facilitated people being able to go out and listen to music and the news. And it contained 4 transistors. Today's communications are through devices like this, which contain over 4 billion transistors. Now, the problem is that many countries are operating with laws that they enacted and have not changed since 1955. And as you can imagine, these laws in these countries are not equipped to deal with the digital world and the realities of the digital world. As an example, on May 5th in the year 2000, the I Love You virus was released. It infected over 55 million computers, resulting in over $10 billion in losses. The Pentagon had to shut down its servers. The person was identified as Odell del Guzman, who is from the Philippines. Although he was identified, he was never prosecuted. He was never imprisoned. Because at that time, the Philippines did not recognize the realities of the digital world. Yes, they had laws that dealt with destruction of property, but they only dealt with tangible properties, not with property of ones and zeros. And so it wasn't recognized as a crime, and extraditions for Mr. de Guzman's arrest and extraditions were obviously denied. So around the same time, a number of countries in Europe, including the United States and Canada, foresaw these new challenges that we were all starting to see, and they negotiated the terms of an international treaty, which is the Budapest Convention. They recognize that cybercrime is an international problem, that no country can deal with it by itself. It requires cooperation among various countries. So after a decade of negotiations, the Budapest Convention was open for signature on November 23rd, 2001, and the treaty was open for signatures. The treaty is basically broken down into three components. Part one deals with four basic definitions. What is a computer system? What is computer data? Who is a service provider? And what is traffic data? Articles 2 to 13 deal with substantive laws, and it basically says, no matter what your legal system is, we have to agree that certain things are going to be criminalized. For example, illegal access to a computer, illegal interception, computer-related forgery, computer-related fraud, child pornography, intellectual property, corporate liability. And the third component has to do with procedural laws. And these are basically, it says again, hey, no matter what your legal system is, you have to have certain things in place in order to deal with the realities of the digital world. Some of the countries were operating under the common law system, others under the Napoleonic system. And in some countries, it's the judges, for example, who do investigations. And it says no matter what your legal system is, we need to do things like have some way to expeditiously preserve data, because we recognize that data can disappear by touching a button. And we don't have the time to get judges sometimes to sign orders, and we need to be able to act quickly. So it encourages countries to be able to have a mechanism to preserve data without the need of a court order. It also calls for certain safeguards. It says, yes, we have to act quickly, but we also have to take into consideration privacy. There has to be a balance between privacy of our citizens and the needs of security. When you walked into this building, you gave some of your privacy when you went through that metal detector. When you go to an airport, they search your luggage. You're giving up a lot of privacy, but again, balanced against the needs and the realities of security, it must be done. But the Budapest Convention, specifically Article 15, says countries, you can't ignore one over the other. You have to have a reasonable balance. So as a result, the Budapest Convention has been signed by over 66 countries. It deals with criminal behavior, but also it has been used as a mechanism to save lives. How is that? Through the signatories, kidnap victims have been identified. A few years ago, I don't know if any of you have ever heard of something called the blue whale. The blue whale is a phenomenon where disenfranchised adolescents find each other. They encourage each other to mutilate themselves and sometimes even commit suicide. I think there have been over 200 kids who have committed suicide. Well, Argentina found that someone in their country was trying to get a group together to do exactly this. And they contacted the Department of Justice because they are also a signatory to the Budapest Convention, and they asked us to intervene on behalf of them with Facebook, hoping to identify who these kids were. Because of the Budapest Convention and the various treaties, we were able to identify the source and save 6 lives, all of them found in Argentina. The treaty is dealing with new cyber issues as well. For example, in the year 2016, it published its conclusions and recommendations involving trans-border access to electronic evidence in the cloud. And this was the basic issue in the Supreme Court case last year, United States versus Microsoft. And that case, as you may know, it involved the question, is an order issued by a U.S. court enforceable when the U.S. provider has transferred those records outside of the United States? That was an issue that a cloud committee, part of the Budapest Convention, had been looking at. Now, that issue was never resolved by the court because last year the United States enacted its Cloud Act, which basically allows these court orders to be respected both when issued by a U.S. court and in some cases by courts outside of the United States. But the point is that many of the findings and conclusions made by Budapest have been incorporated into this new act. As you can see, I'm high-tech today. So capacity building is also an important component of the Budapest Convention. We try to do training on a regional basis, and we work with other international organizations. In this hemisphere, we've worked with the Organization of American States, with the Department of Justice, and with the State Department. We've trained over 2,000 legislators, judges, prosecutors, and investigators. And it has been training that has been given careful thought. Instead of just organizing training, come if you want, we have been very careful in deciding where to hold this training. We try to select countries that have shown a true interest and a commitment to this issue. Not just always going to Buenos Aires, which is fabulous for steak and wine, but countries like Ecuador or Paraguay. I'm not recommending anyone go to Paraguay. It's one of the most boring countries. But they have shown a commitment to cybercrime, and they were worthy of hosting one of these regional trainings. The participants are carefully selected. We try to identify people who really need this training. Judges, for example, who come in contact with electronic evidence but don't feel comfortable determining the admissibility of electronic records. We try not to select the same attendees. I've gone to train in a number of these various conferences, and it always seems that it's the same people attending to hear presentations by the same people. So it's like a family gathering, and that's something that we've been very aware of and we've tried to avoid. The trainers are very carefully selected. We want trainers who understand the cultural subtleties that are involved, who go down to a foreign country and don't start talking about the Red Sox versus the White Sox, because people scratched their heads and said, "Sox, what does that have to do with anything?" We want trainers who speak the language. A lot is lost through translation, especially when we talk about technical issues. We include forensic experts, for example. In finishing, I want to recognize both the Department of State, particularly INL, who without their grants, none of this would have been possible. None of this. They are the most significant contributor to the Budapest and Council of Europe. I want to also recognize the Department of Justice, who have provided, particularly the Computer Crime and Intellectual Property section, who have provided the needed leadership to not only negotiate the terms of the Budapest Convention, but they've also been a source of very qualified instructors. And combined with these, we've had the type of success, and hopefully we'll continue to receive those funds, because funds are being tighter and tighter to receive. We recognize that, but I also want to be on record to thank INL. Thank you.
Thank you, Rudy. I think you raise interesting points that we'll explore further about kind of considerations that inform effective capacity building in general and in this area in particular, and the tie between capacity building and policy objectives like accession to the Budapest Convention. But the organizers did ask me to make clear that Rudy's views on Paraguay are not necessarily shared by the ABA, USIP, or the U.S. State Department.
Diplomacy has never been my strong point.
Never having been there, I'm sure it's a very interesting country. We'll turn over to Kenn now.
Good morning, everyone. On behalf of District Attorney Cyrus R. Vance, Jr., the New York County District Attorney, I just want to thank ABA and USIP for the opportunity to speak with you today, and good morning to everyone. A little bit about our office. We are, at its heart, a local prosecutor's office. Oh, it's not? Okay. Thank you. Thank you. So on behalf of District Attorney Cyrus R. Vance, thank you so much for the opportunity to speak with you this morning. We are, at our heart, a local prosecutor's office. We handle approximately 60,000 to 100,000 cases a year based on volume of criminal activity. And what that really places is that we become an emergency room of society. And what happens on the streets of Manhattan come into our doors, and we have to study it, analyze it for our work in investigating, exonerating, and prosecuting. At the same time, because of our physical location in Manhattan, we are also an international office. Our jurisdiction, because of Wall Street and because of some technological jurisdiction issues, gives rise to an opportunity for us to view the lens both as a local office and an international one. And so we, in trying to address the scourge of cybercrime, we see it affecting not only our local institutions and our residents, but our international partners and international citizens. So we've had to think differently and act differently because of that. We've invested in personnel. We've invested in making sure that we have a high-tech lab to process all the things that were coming in the door. The same thing that if you were focused on DNA in a medical case, you need to have the tools and equipment to focus and drive these cases, and to educate your staff to be able to have conversations with judges about why these cases matter. The other thing we've had to do is really change the way that we place personnel. So we have secondments as a local prosecutor's office in the city of London, Paris, Singapore, and in Israel, because of the threats that those are central cities for us in trying to combat cybercrime and financial crime. The district attorney's general operating principle has always been, it is better to prevent a crime than try to address it from a defensive posture. So we've had tremendous investments that I'll talk about in a few minutes about how to go ahead and try to prevent more of the cybercrime that we're seeing, and not to just admire the problem or be frustrated by the problem of cybercrime, which is where I think many of our citizens are throughout the world. You see a hack, a story comes up about 150 million people, there's a wow factor, and you move on. In addition to making sure that we don't just admire the problem, that we try to prevent it, we've had to become more sophisticated international office. We share some of the same principles that Rudy articulated about having staff that can speak across borders and to work with colleagues throughout the world, because that is the only way you can do cybercrime and focus on it nowadays. So when we talk a little bit about the threats of cybercrime, what I want to just show to you are 3 initiatives, 2 very positive, and 1 that's been troubling for us as an office. You can imagine that as law enforcement officials, there is a desire to bring people to justice who are committing these, irrespective of constraints of borders. So we abide by, of course, all the international norms and follow the policies associated with those and work with great federal partners, many of whom are in the room today. We have also, as a local actor, been constrained by some of the time-sensitive issues related to prosecuting these cases. Criminals operate with the speed and agility across networks and borders, and many of us at the state and local prosecutor side, which handles approximately 95% of the cases in the United States alone, did not have the ability to react in real time. So you're constantly playing defense, and you're constantly slow-footed. In order to change that, the hope that the district attorney said is, let me try to invest in initiatives that focus on both prevention and an international framework. So I'm going to focus on two of them. And I have a deck, and I'm set to go if you are, sir. Thank you. Fortunately, it's not moving ahead. Cybercriminal. But I'm not going to waste time, but as you're getting it, I'll talk a little bit about it. The district attorney on one initiative called the Global Cyber Alliance created this initiative, a nonprofit, because in terms of playing whack-a-mole with criminal cases, we can't prosecute our way through this problem. The only logical solution is to try to continue our enforcement work, but also develop skills at prevention. So the district attorney with the City of London Police Commissioner in September of 2015 created an initiative called the Global Cyber Alliance. It's an international organization that it's really predicated on how do we move real-time data across sectors and countries. And we came into this in trying to aid the district attorney as to whether this was a worthwhile investment, saying, doesn't this exist already? And of course, there are tremendous initiatives that exist throughout the world. But for our vantage point, we were not necessarily privy to some of these. And when we spoke to our New York partners in cyber professionals in New York, they were certainly not aware of some of the opportunities to share across borders and sectors. So the Global Cyber Alliance was created, a separate nonprofit from our office. 4 years later, we're very proud that there are 250 partners across 18 sectors in 28 countries. The sectors represent the gamut of ones you would think of, from critical infrastructure to entities that wouldn't necessarily appear as top of your mind. Educational organizations, our schools within New York who are constantly being hit by cyber attacks, with all the intellectual property that's at our academic institutions. The board of directors is from around the world and from all different sectors. When we first met at the Federal Reserve Bank, the district attorney asked this question: what is the first project we should get involved with? And around the room, the heads of Bloomberg, Citi, our partners in France, London, all without a doubt said phishing, to which the district attorney said, how boring. Phishing? This is what we should be, and he didn't take long to be convinced, of course, that, as many of you know, phishing is at the root of most of the problems that exist for cyber. And so what the Global Cyber Alliance did is create a series of tools free of charge that one can go to the website, globalcyberalliance.org, and download tools that can assist in terms of prevention of attacks on email, which is DMARC. Quad 9, another free tool which deals with threats against the internet. And we recently released a tool for small businesses. When we looked at what was happening in New York, we felt that there was an economic disparity. Large institutions could invest in cybersecurity, but the heartbeat of New York is small and medium businesses, and they were getting priced out of the opportunity to protect themselves. And as everybody knows, the large corporations have, its chain is based in the small business community. So the Global Cyber Alliance is an initiative that we believe in capacity building. How do we take all the expertise that we have with around the world and unify it and produce things that are helpful for our citizens around the world? I'll spend 2 more minutes. Another global but rooted in New York is the threat to our critical infrastructure. So about a year ago, the district attorney said, in case of a cyber attack, are we, New York City, ready and prepared? And the answer was not enough. And so the district attorney, along with partners with the Global Cyber Alliance, the police commissioner of NYPD, and New York City Cyber Command, created the New York City Cyber Critical Services Infrastructure with one primary mission. How do we protect New York City from threats around the world when we know we're not doing enough to share that information in real time, when an attack against Con Edison, our electrical provider, or against Wall Street isn't being moved to the other sectors within New York? So for over time, we have now brought together about 37 different organizations, again, focused on New York, but an attempt to address an international problem. The threats that we see are both local, national, and international. But JetBlue wasn't communicating with HBSC or IBM or Booz Allen. And certainly what we have noticed is that the biggest threat is to our hospitals and our healthcare facilities. As you all know, the United Kingdom went through the crisis of having its doctors and nurses unable to access medical records last May. And if you think that, if a judge or anybody ever thinks cybercrime is a zeros and ones, as Rudy put, and we both share the philosophy, of course it's not. It affects real lives, and that's an example of a real life problem. So sectors represented in New York: small businesses, media organizations, financial. State of Michigan was way ahead of us. 5 years ago started this. And figuring out how do you prepare at the local level for attacks, given that you've got to respond in real time. And that if you are going to have a citizenry that is in panic stage, unless you have the tools in place. When you need to smash the emergency glass at a company to get to your operating plan in case of a cyber attack, what's the plan for the city itself? New York City, 8.6 million visitors, 1.8 in Manhattan alone, 1.8 million people residing in Manhattan. You are trying to stem chaos and make sure that what's behind the glass is a ready-made plan for what to do and who are you talking to. And we, as part of that, have started to do trainings in cybersecurity to protect our infrastructure. And sadly, we did have to go to Boston because New York doesn't have some of the things that would allow us to train together, meaning state-of-the-art facilities. But Boston does and IBM, so hopefully New York will catch up. Finally, I'm not going to go into this to too much detail because of time, but I do want to say that those 2 initiatives are so promising, bringing together institutions, people to share and collaborate and give tools. But as prosecutors, one of our biggest challenges that we face as we try to balance privacy concerns with our judicial orders is the issue of encryption. So I'll save that and turn it back to you.
Thank you, Ken. One of the aspects that struck me from your presentation was the need for collaboration and the capacity for rapid response, not just at the State Department, and this is just me, but I tend to think about it as between and among countries. But we have to think federal level with state and local, government entities with the private sector, among sectors. So thank you for fleshing that out and reminding us of that. The capacity building has come up in each of the interventions at this point, and I think Mary will now elaborate a bit and share some of the experience and perspectives of ABA Rowley in that area.
Thank you, Rob, and thank you to my panelists, and greetings to everyone. Wanted to make sure that I bring us back into a conversation that we started during the opening remarks, where we're trying to identify what rule of law strategies can be most effective in virtual spaces. And I have lots of colleagues in the room from DOJ OPDAT and ABA Rowley and other implementers and donor agencies, so I'm excited to have further conversation after I talk a little bit more about the how and the why in terms of technical assistance and what rule of law strategies we've already designed and developed and what we can do better. But I wanted to start with the why, because I'm not sure we always do that as effectively. But the why is, as my colleagues have mentioned, it's really about peace and security at all levels. It's about the peace and security of countries, financial, physical security of individuals, businesses, communities, hospitals, schools. And the how, I have some general observations, and then I want to talk about some specific examples. But I kind of have three buckets of observations, some of which have already been brought up by Rob and Kenn and Rudy. But first of all, and I lifted from Kenn's PowerPoint the motto for the Global Cyber Alliance. Our philosophy is simple: do something and then measure it. I think the most effective technical assistance in the rule of law realm are programs that are designed after thorough assessments, and assessments that identify gaps in laws, resources, frameworks, and that those assessments are ongoing. There's logical gaps between the time when we at Rowley might submit a proposal in one of these areas and when there's a decision on the funding and when the implementation actually starts. So the assessing has to happen all along the way. And the measuring, during the course of the implementation of a program, but most critically, identifying what you're trying to change and did you actually accomplish that? Are people safer and more secure? Are defense lawyers incorporating into their practice? Are prosecutors incorporating into their day-to-day strategies around enforcement because of what information we shared and the expertise that we helped create? So do something and measure it. And then the second general bucket of observation is I just kind of call it breadth and depth. To me, breadth is logical as rule of law implementers, especially as part of the American Bar Association, is we're working with justice actors. And in some countries, we're working with a variety of justice actors, and including the defense bar. But as my colleagues have already mentioned, you can't just deal with this from an enforcement. And you can't just deal with it through the ministries of justice and the justice actors. We also want to work with the judicial training academies, with the Supreme Judicial Councils, and other entities that are critical at the juncture of implementing rule of law programs and strategies. Inspectorates, the lawmakers and the regulators, and then the economic groups and consortia. And as my colleagues already mentioned, we have to work regionally, if not globally. The breadth has to be wide and strong. And in terms of the depth, we have to work, as Rob mentioned, at the local, the national, and global level. And we want to work with individuals and business owners and global corporations and civil society actors in order to address this. The third general observation I have is we have to be strategic thinkers. I'm a recovering prosecutor, and a lot of times you did not have the evidence. You knew something had happened, you knew who did it, you didn't have the evidence. So what else can you do? You might file a different, Rudy outlined for us the variety of types of criminalized behavior has been modeled for us through the Budapest Convention. It may not be the highest level of felony that you can file, or you may have to go after someone's permit or you may have to go after their bar license or something. You have to try to do something to not, if you're not able to do the enforcement measure that you think is most appropriate and most deserving, you may have to do something else. I appreciated our keynote mentioning the diplomatic channels. You know, we've all worked in countries where we've worked with our colleagues from the embassy, whether at INL, the polyecon officer, someone who can help us put a little diplomatic or political pressure on relevant actors so that we can make the progress and the changes that we desire. The sanctions, the asset forfeiture, seizures. My colleague Catherine is here from DOJ OPDAT. You know, a lot of us have worked together to try to create specialized units, multidisciplinary, multi-agency task force. And those are the most appropriate ways to deal with highly specialized areas like we're finding these virtual spaces and cyber issues to be. But you can't forget the conservation officer in Tanzania, who's probably going to be the one who's going to identify who's trafficking, I'm not going to mention flamingos, but maybe rhinos or something, or the street cop in Tbilisi. You can't forget to train at all levels and at all levels of expertise that everyone needs to have the basic tools that Ken and his colleagues have been identifying and furthering. And lastly, you know, our keynote mentioned the tightly governed spaces. You have to find common ground with the actors and the countries and the governments that don't appear to be budging, and as a matter of fact, appear to be just tightening the noose. There has to be common grounds and strategies that you can find. In terms of furthering the how, I have 3 specific areas of technical assistance that I'd like to highlight from some of our work, and I really am excited that we have other implementers in the room to talk about other areas. But, you know, Rudy spent time helping us become more familiar with the Budapest Convention, but basically tying technical assistance, this is not new, but it's really critical in this area, to international practices and conventions and standards. A couple examples of that, you know, a lot of us are familiar with the UN's 2030 Agenda for Sustainable Development. This is the development goals. And one is intended to harness information and communications to advance gender equality and women's empowerment by accessing the internet, accessing information, and increasing public participation. My colleague Liz is here. We had a program in Malaysia where we convened a workshop for lawyers, journalists, and human rights defenders on the feminist principles of the internet, sharing information about digital security and privacy rights online. I've been tipped off that the second example I'd give is many of us have helped further mock trial competitions, and the largest is the Jessup moot court competition. I've been tipped off that this year's fact pattern is going to include killer robots in the fact pattern. AI. Okay. All right. And then my second area of specific types of technical assistance, back to the regional work, working with regional bodies on a regional basis. And a couple examples of that, we have programming in Southern Africa where we're working with the African Prosecutors Association and the South Africa Development Community, where we've worked on trafficking issues in that region of Africa. Thanks to people like Rob and other people at INL, we have, I think since like 1999, we've had a regional anti-corruption program. Starting in the Baltics, Central Asia, now headquartered in Thailand. But through that program, our regional anti-corruption advisor, in 2017, we coordinated with the U.S. and Vietnamese governments a conference around trafficking in wildlife and illegal logging, where we partnered with the Asia Pacific Economic Cooperative, the APEC, where we brought together over 100 participants sharing information about how to most effectively combat wildlife trafficking and illegal logging. And then the third program we're just kicking off, I got to be in Ethiopia last month. We're working with the African Union, where we're developing strategies to enhance the capacity of the staff of the Secretariat of the African Union to deal with the global breadth of the challenges in their member states. My last bucket is I want to talk again about breadth and depth. And I don't know if my colleague Ashley Martin is here, but we had a 2-year program through the good graces of the Department of Human Rights and Labor at the State Department, where we dealt with internet freedom issues. And we furthered those efforts that have been described by my co-panelists, where we tried to bring in the public sector to deal with the private sector to deal with public agencies, and working with civil society actors, much through which we were able to subgrant the funds that DRL gave us. We worked in 18 countries, 11 of which were in Europe and Eurasia, and 7 of which were in Asia, to build the capacity of lawyers and civil society actors in the areas of freedom of expression, association, and the flow of information. A couple things that we accomplished during that 2 years through our partners. There's an Internet Freedom Network comprised of 10 local partners. Through that Freedom Network, there were 11 country-specific state of affairs reports, where there was analysis about what the gaps were legislatively in terms of resources and those kind of things. And then products were developed, including in Armenia a multimedia toolkit informing civil society actors, government representatives, and internet users writ large about existing and emerging digital threats. We created a lawyers network within that regional body, where the lawyers got better at assisting victims of events that occurred in the cyber realm, as well as representing actors who were being prosecuted through some of the overreaches of governments in their efforts to try to restrict this space. And lastly, some of the countries we worked in were very sensitive countries, and in one of the areas we brought together representatives from the regulatory authorities, private businesses, and civil society, where we started a dialogue and a multi-agency working group to improve the legal and policy framework around information restrictions. So in conclusion, why are we doing this? We're doing it because it involves the safety and security of our partners in our countries, the countries in which we work, and on a global stage. So invite all of you all to share some of your strategies and stories and challenges and success stories. So thank you.
Well, thank you, Mary. Thoughtful comments as always, and I happen to know that you're not only a recovering prosecutor, but a recovering defense lawyer as well. And maybe at the end, Ken would use a couple minutes of your time when he realizes he has to go back home and say that he admitted that Boston has something that New York City does not have. So I have to apologize to the audience. These interventions have left nothing interesting to comment on, no questions in your mind. We've completely settled the issues. We can take some extra time at coffee. Now, all kidding aside, we're going to open the floor now. I don't know what the system is for sharing mics, but yeah, we've got a floating mic. So again, if you just say your name and your affiliation, and we invite comments, I would suggest that they be relatively brief if it's a comment, or questions for the panel. If questions, we'll take 3 at a time. So we're opening it up.
Thank you. I'm Peter Bauger. I'm on the Rowley board. Delighted to see you, Mary. Tell us a little bit about how these various efforts that you've been talking about, or what we can learn from the Budapest Convention, impact private actors. For example, to take one that's been in the news, Facebook is faced with a huge volume of traffic, some of which it would like to filter. How does it do that appropriately, and to what extent are there rule of law either models or maybe actual statutes that would inform how private actors with a big opportunity to impact ought to function?
I think we'll take a couple more.
Thank you. Katie Wang with NTD TV. My question is about China because, as you have said, that China is not signed on this Budapest Convention, but is also actively involved in this state-sponsored cyber attack, and also it controls the online freedom of speech and so on. So it also promotes this concept of cyber sovereignty. So how can you deal with China on different aspects? Thank you.
Good morning. Thank you for your comments. The internet has evolved much over the years. I worked with the folks that brought you the internet originally, and we've developed new methods where the internet is no longer end-to-end in the moving forward. That was sort of a first cut at how to do it. And this gentleman talked about the Budapest, and you have the computer data, and how do you preserve that? Well, I've had some conversations recently where the digital entity itself, the data, how do you incorporate it in a computer program? Because basically you're talking about zeros and ones, as you mentioned. And if you actually are protecting the information itself and resolving to that information itself, you have a fighting chance about how to preserve and manage and at least try to hold back the tide of illegal access to perform stated operations on those sequence of bits. You actually also have a way to manage the global infrastructure. And we set up a foundation in Geneva called the Dana Foundation. And it's based on an old DARPA project going back 25 years, where actually it's come forward now, and we're using the newer security, obviously, but it's based on the notion of not just end-to-end, where you resolve to the ports of machine, but you're actually managing the information units itself. And I'd be pleased to provide you some information about that. Now, the Budapest Convention, 2001, is there a possibility of evolving the concepts? Because you're not just transferring records or preserving data. Data has gotten to be one of those words that, what is it, information? So the information has to be represented in some form. So how do you preserve and manage over long periods of time the access to those units of information? And that's what we spent an enormous amount of time over the years on. And we're most pleased to share that information with you.
Thank you. Okay, so our three initial questions, one, and I'll paraphrase, is how these efforts have impacted the private sector, and I'll add, and how has the private sector contributed to the evolution and impact of the implementation of these efforts. Working in the context of countries that have very different views about the appropriate nature of the internet and roll towards cybercrime, and issues of the need for our legal approaches and perhaps our conventions to evolve in light of evolving technological approaches and recognition of new needs and issues of preservation of data. So I'll turn it over to the panelists, whoever wants to jump in first.
I can jump in just with some remarks on, from our vantage point in terms of private sector, the initiatives that we laid out and the way that we have to approach short-term and long-term cybersecurity issues goes through the heart of the private sector. While the government sector, of course, has excellent professionals and a certain amount of bandwidth, in truth, the private sector has the opportunity to, with 2 billion users at one company, have global change in a heartbeat. So for us, I think the approach has been that we are constantly collaborating with the private sector, constantly listening to the private sector, and making sure that we are never missing an opportunity to leverage their goodwill, both at the state, local level, and global level. We're all in the same boat, trying to address these cybersecurity issues. And so for our collaboration with Facebook, we deal with it. We deal with them constantly, and there are several initiatives that we can talk offline about.
Just wanted to chime in on the private sector issues. One of the other rule of law strategies we've identified that's important in any rule of law programming, but especially in this space, are public information and public education campaigns. And that's especially acutely needed with the private sector. And yeah, that's all I'll say.
Okay, I'll address the China question. How do you deal with countries that are not signatories? Countries generally that are not signatories generally fall into three categories. You have less developed countries, countries that really don't depend much on e-commerce. I don't want to use Paraguay as an example, but I'll talk about Paraguay. And they usually do not wake up until somebody very important in their country has been the victim of an attack. For example, in the Dominican Republic, who is a signator, they got mobilized when the president, a few years ago, their president, was the victim of a cyber attack. All of a sudden, what is this? And they mobilized. Now they're one of the leaders in all of Latin America. The second category would be those regimes that are more restrictive, the China, the Russias, for example, who are very concerned about maintaining their sovereignty. They don't want the Budapest Convention coming in and allowing judges in France to issue orders for China to be obligated to turn over records. That's a huge issue. And there you have two diametrically opposed legal systems that may never come into an agreement. That's just the reality. And the third category would be what I would call countries that have a type of complex. Countries, and again, I don't want to be specific, but since we're talking about Brazil, Brazil is a country that is promoting the negotiation of a totally new treaty. And they always come up with a different excuse why they don't want to sign the Budapest. At one point, it's because they were opposed to one of the articles having to do with intellectual property enforcement. Then they came up with another excuse. And within those countries, there are divisions. So it's like countries saying, hey, we're not a third world country. We should have been involved in the negotiation of this treaty, but since we weren't, let's start a new one where we can get in at the ground level. But the problem is, as I mentioned earlier, the Budapest Convention took over a decade to negotiate. What do we do in the next 15 years while we negotiate another treaty? Do we just totally abandon Budapest? Our suggestion was join Budapest, Brazil, and then negotiate any new terms that you feel are important or that may have been ignored. But to suggest that we're going to totally abandon the Budapest Convention and then negotiate the terms of a new treaty, that's not realistic.
I'll note that among the Budapest Convention's 63 or so states parties, I may have the number off, are both Council of Europe members, non-Council of Europe members that are developed countries, and a number of G77 or developing countries. And then it's estimated that another 60 countries that are not parties to the Budapest Convention have modeled their laws on its provisions. Let's open it back up for more questions and comments. And again, please just note your name and if you have an institutional affiliation. So if you guys would pass the mics around.
Good morning. My name is Jeanette Manning, and I'm an attorney with the National Association of Attorneys General here in D.C., and I head up our international center. And my question actually is probably more geared towards you, Ken, with respect to, you had a slide regarding encryption. Can you talk a little bit more about advances you're seeing, particularly as it relates for law enforcement? Are they starting to make more headway with private entities, these social media giants and others who are now starting to hopefully cooperate as it relates to investigation? So can you elaborate on that?
Good morning. My name is Orlando Munoz. I work with ABA Raleigh in Colombia, South America, and my question is to Rodolfo. could you please provide more details about the Argentinian case of the, I mean, how Argentinian authorities acted against the blue whale game?
Okay, we'll take one more. Some more hands up earlier. Oh, there we go.
Hi, good morning. Thank you again for giving us this panel. My question is for Mary, because you mentioned the feminist principles concept in internet security. I was just wondering, what are you seeing as the major challenges or gaps in the ability for law enforcement to bring cases specifically around cyber mob attacks, those that limit women's participation in the internet, and when those sorts of online mob gathering in an organization lead to physical violence or threats of violence?
Thank you. So we have encryption, Argentina. I was terrified for a moment that you were from Paraguay. And law enforcement responses to cyber mobs and online aggression against women.
All right, I'll start with Argentina. Buenos días. Yeah, the Argentine authorities got through social media, specifically through Facebook, this message, and they recognized what it was. They try to reach Facebook to get subscriber information under the emergency exception. There's an exception under our law that says when you have a life-threatening situation where there's the potential is imminent that someone's going to lose their life, service providers may, in their discretion, provide records that are necessary. Facebook refused to turn them over, and this goes to one of the questions that were asked earlier: the role of the private sector. So they contacted the Department of Justice, that is, Argentina did, to help, to see what we could do. We recognized that this was an emergency, so at the time I was working for the computer crime section. I called Facebook, and they said, this is not an emergency. My response was, you know what? This is your decision. But if somebody ends up dying and they ask the Department of Justice why we didn't act and the impact that may have on the value of your shares, whether they go up or down, that's your decision. We got the records within 2 hours. And with those records, we were able to find the locator information, the geolongitude information, and I was able to actually see the house from which that Facebook message had been sent, which I provided to the authorities. They identified the individual. He was a 16-year-old, very disturbed individual. They found out the other people he was communicating with through his computer, and as I said, they were able to save about 6 lives. Okay?
Thank you for the question on the feminist, the law enforcement issues around cyber attacks on the internet, threats of violence. I don't have any, I turn to my colleagues here and in the audience for any specific examples from a rule of law implementations, but I'm strategy or issues, but I'm imagining that the investigative challenges are real, and it's what we've already identified. The access to electronic evidence in real time. Let me start with political will by either governments or investigative agencies. The challenges with obtaining electronic evidence, threats of violence are definitely harder from an enforcement standpoint than actual assaults or actual stalking, actual hate crimes. And then the attribution issue, which my colleagues that are better at the use of electronic evidence can maybe elaborate on.
So thank you very much for your question, and it actually will allow me to tie back to your earlier question. With the audience permission, I'll do a 2-minute primer on encryption. My comments throughout are never criticizing any particular entity. It is an observation for you in terms of what the impact has been for us in the state and local community on the very practical path that we have, which is to investigate, exonerate, and to prosecute. So this issue for us, the going dark issue, has been around for decades, but it hit the state and local community most in a few years ago in 2014, because from a data at rest perspective, your phones, these are the devices that we typically, in the past, had been able to, in every instance, go to a judge, get a warrant, take that phone that's associated with an accused actor, ship it off to a California entity, and based on the judge's authorization, get into that phone, as we're focused on human trafficking, sex crimes, whatever the case. A judge has read our application and made a decision. But in 2014, Apple made a decision to change its operating system. That's their private sector choice. The impact that it had on us was dramatic, to say the least. Now, why does it matter is because Apple and Google control, because of their market share, about 99.3% of the operating systems around the world. For our office, as I talked about in my initial comments, we run a state-of-the-art lab. Very proud of it. No matter how many terrific professionals we have or the tools we use, we can't get into most of these devices. 2,000 devices that we lawfully obtained since 2014 were inaccessible when they were seized. More and more of these devices, because of the operating systems, just come in and they are inaccessible to us after we get a warrant. Again, remember, we have the legal authority, but not the physical ability to secure it. Where are these cases coming from? These are 9% of them are homicides or attempted homicides, real-life issues. 10% of them are sex abuse cases, including child sex abuse, human trafficking, around 7%. And then the unique thing is, from a cybercrime perspective, these cases, about 30% of them are related to cybercrime. So we can't get into the phone trying to tackle the evidence to just examine it. We could exonerate, but we can't get to it in cybercrime. So we're asked to investigate, but we can't get into the evidence. Let me just talk a little bit about what the practical implications are. Videos on these devices affect our investigations of sex crimes, human trafficking. When we look at these, these videos were strong corroboration of the victim's, a 13-year-old girl's narrative in which she described the defendant entering her bedroom and assaulting her. Talk about the most dramatic cases. When I talk about exoneration and the need to get into these devices, I'm not playing lightly. I'm saying we've looked at this, and in 17 instances, because we were able to get into the devices, a man or a woman who was accused either had their charges completely erased or they were reduced. So to your core question, are things getting better or worse? Worse. Much worse. We can't get into the devices unless we spend a lot of money to outside consultants to do it. And when we're dealing with not data at rest, but data in motion, when we're trying to do our wiretaps, we're frozen out. So this is not a tech problem. No one's pointing the finger at the tech community. This is not a law enforcement problem. This is a societal issue. So we're all in this trying to grapple with how do we balance public safety, threats to critical infrastructure, threats to all the things that I talked about on the earlier initiatives, and privacy. And we are stuck. We're in a really tough place where the victims of our cases, we cannot get to the evidence. And so what I will say is we have put together every year a white paper on the subject. You can just visit our website, manhattanda.org, to access those. We approach it as neutrally as we possibly can, but with a clear, underscored emphasis that from a public safety position, this is untenable. So, sir, back to your question about the private sector. In every sector, except for the tech sector, We have a robust, at times, there can be friction, but in the tech community, it has been really difficult. Now, that has gotten slightly better over time, but not much. So I wish I had better news. And sorry for taking up so much time.
So we started a little bit late, but I don't want to take us too much later or go into the next session. So I'm going to take 1 minute and just mention some of the themes that jump out from the presentations and from the discussion of the questions, and then we'll recognize our panelists. So from my perspective, some of the themes that stand out are the need for adequate legal frameworks as crime has evolved, the idea that having common elements among countries helps with international cooperation, and the importance of capacity building and thoughtfulness and drawing upon lessons learned in capacity building. The importance of not just thinking, as I unfortunately often do, of federal entities or country-to-country cooperation, but sub-federal entities or subnational entities and cooperation that is vertical and horizontal, and the constraints, but also the innovative approaches that states and localities have in confronting these issues. The fact that we have to treat it as a multi-stakeholder issue involving the private sector. And thank you for raising the point of the constraints and the challenges for small and medium enterprises that we don't always think about. We often think about the behemoths in the field. The importance of rapid responses in all of those directions that we mentioned, and of planning and preparation, the point that a criminal justice response, in a sense, is a response when it's too late and we're in a defensive posture. And then, and this could be another hour, 2 hours of discussion, the balance of privacy and security and the challenge of encryption. So I'm sure that you are with me in having found our panelists to be articulate, thoughtful, comprehensive, responsive. If you'll join me to both thank them and thank ABA and USIP. And I'm sure they would be happy if you buttonhole them for more side discussions.